I don't know how many of you are familiar with Life Legal Defense Foundation. We've been around since 1989. We were started by attorneys who saw pro-life advocates being wrongfully prosecuted and having their civil rights violated. And our mission is to give innocent and helpless human beings of any age, particularly the unborn, a trained and committed defense against threat of death. And we do it through the law, obviously, and through education. And so this is one of our educational outreaches. If you are interested in other continuing legal education that we've presented, we do have something online right now. If you go to our homepage, there's a green bar across the top that says CLE. If you click on that, it's I think it's 2 or 3 continuing legal education credits on the issue of free speech, which relates to a lot of what we do. People who are either on college campuses, somewhere in the public fora opposing either abortion or euthanasia, and sometimes even human embryonic stem cell research. So today is going to be pretty policy heavy, although we do have some model pleadings in your materials. And this is going to be kind of confusing for me because I've gone through this many times, but I've done it with my laptop, so I'm going to have to turn today. So if I get discombobulated, please excuse me, but I'll get back on track. The one thing that I want to mention is that part of what we're doing today is an attempt to try to start a network of attorneys who will be able to handle these cases and who will be able to advise their clients that the best thing they can do to protect themselves is to have an advance directive that is pro-life, that protects your life from a forced death. At the outset, many people do not know that food and water is considered medical treatment. And so it's very easy to dehydrate and starve somebody to death in the name of we're stopping medical treatment. And so this is what we're focusing on today. And as we get into the day, I'll talk about some of the cases that we have either helped litigate or litigated and sort of fill you in on what's going on in the medical industry. And it is indeed an industry. There are a couple of other things I wanted to point out to you that may be helpful. The first, I do not have copies with me today. We're out of them. But if you go to our website again, resources, our newsletter, Lifeline, we have an analysis in this particular issue that you can print out on Obamacare, both from the perspective of abortion and then also from the perspective of forced death and active killing. And just real briefly, if you look at that article, it will give you citations to the actual sections in the Patient Affordable Health Care Act, and these are the risks. Inadequate medical care for elderly patients, rationing of health care, I think that's painfully obvious, loss of patient control over decision-making, which is a lot of what we'll be discussing today, and then, of course, the loss of conscience rights, both for the patient and for people who are providing medical care. So if you want to look at Obamacare from our perspective, that's available on our website. The other thing that I want to direct you to, that I did bring copies today and I forgot to put them out, but if you want one, see me after. We have a pamphlet, Make Your Healthcare Decisions or They'll Be Made For You. And this is something that might be helpful to you, might be helpful to your clients if you're an attorney who prepares directives. And then something else that we're going to be working on and that I think we're going to have a little sort of meeting after today if anybody's interested in staying. We're going to be working with Legal Lifeguard, a organization based in Phoenix, Arizona, that provides help with directives and with financial planning and doing it from the perspective of continuing your beliefs when you have died a natural death because you have a good directive, and being able to pass that on to your family, so to speak. Another good organization is Patients' Rights Council, formerly the Anti-Euthanasia Task Force. We have some information about them on our website as well, and we'll be adding Legal Lifeguard soon. So those are some resources for you if you're an attorney or if you're a layperson attending today. So on to the sort of the guts of what we're doing today. I'm a very emotional person, so I'll cry today on and off because this is just thinking about it, it's a very emotional issue for me. And when you're involved with these cases legally and you're in court and somebody's life is depending on your legal skills, it gets really personal. And I know that we're told all the time that don't make it personal. Good attorney doesn't make it personal. I happen to disagree with that. But I want to talk about something today that I'm a Dateline on ID junkie. Lots of things about, forensics and things like that. And I was just happened to be preparing for this, and I was watching a Dateline on ID called The Devil You Know. I don't know this lady. I just thought, this is a classic example of what we're dealing with in our culture today. The lady's name is Heather Grossman, and her ex-husband shot her in the neck when she was driving in a car, and she was taken to the hospital. She's now paraplegic in a wheelchair, and the first thing that was said to her mother when she was brought in by the nurse in the ER was, personally, she'll be better off dead. I mean, think about that. Personally, she'll be better off dead. Now, that's really great for that lady to say, because personally for her, maybe she would be better off dead, because people don't like to deal with disability and imperfection in our culture. But I watched this segment, and I got through the whole thing, and at the very end, she met the doctor that saved her life. And he said, Heather, you begged me to let you die. You begged me to let you die, and I wouldn't do it. So that kind of juxtaposes what you could encounter in our medical industry when you're, perhaps in that position. Thank God, she said, he did not let me die. So he gave her care. He made sure she got treatment for depression. She got the counseling that she needed. And she now lives a full life. She's still married to the husband that she was married to when her first husband shot her. She has 3 kids, loving family. She counsels people who have disabilities much like her. She lives a full life. And again, she said, thank God he didn't let me die. So do you know your medical professionals? Do you know what kind of approach your doctor would take? Do you know what kind of approach your hospital would take if you were in this condition? These are important things that I think that we don't consider because we still assume in our culture that the men in the white coats have our best interests at heart. And my experience has been that they do not. Now, of course, maybe my experience is jaded because we've got people calling us that need help. But I would dare say that with the advent of Obamacare and many other things that are going on in our culture, that's just going to become typical. So, see if I can do this. The CLE, Act of Killing What the Law Allows, had its genesis with the case of Robert Winland, who is a gentleman that lived in Lodi, California. I don't know if any of you have heard of the case of Robert Winland. Very eerily similar to Terry Schiavo's case back in 1997. And this was a case that Life Legal did not litigate, but we helped with research and funding. And this is where this continuing legal education came from. We presented it about couple of years after the Winland case began, and we've just updated it, done our shepherdizing. I want to mention Rebecca Millard, who's here today. She's one of our staff attorneys in the back, and she helped do the research and get everything up to speed for what's going on currently. So its genesis is in a real-life case, and we'll talk about that today, and there's information in your materials about the Winland case. Okay. Cases involving the issue of life-sustaining treatment are proliferating, obviously. And again, they will proliferate, I think, at a huge pace when the government takes over our health care. They have to. It can't sustain itself. The actuary for the federal government, who happens to be an employee of the federal government but sort of hands off, he's an impartial party. He's said it cannot sustain itself. So we will see rationing of health care. We're already seeing it in private industry. Again, the name Robert Winland, Terry Schiavo, and I won't even attempt to pronounce this lady's last name, Rachel. If you turn to page 1 in your materials, this was a lady whose case was a little bit different in that she was an immigrant. She was a legal alien, and she had a medical condition with no health insurance. Medicaid would not cover it. Her sons did not have the means to provide the health care that she needed. And so the hospital gave her sons an ultimatum and said, you need to have a public guardian appointed to make health care decisions. And this is what the public guardian said in some emails that the attorneys that litigated this were able to get through discovery. And if you look at page 1 and on to page 2, I think that this is pretty stunning stuff, and so I'm going to read it. Ms. Sloan was the guardian, and she viewed her job as protecting the best interests of society, not her ward. So much for fiduciary duty. And she stated that hospitals cannot afford to allow families the time to work through their grieving process by allowing the relatives to remain hospitalized until the family reaches the acceptance stage, if that ever happens. She went on to say that, generically speaking, what gives any family or person the right to control so many scarce healthcare resources in a situation where the prognosis is poor and to the detriment of others who may actually benefit from them? Well, generically speaking, what gives any one family or person the right? The Constitution of the United States. You have a right to life, you have a right to receive medical treatment, you also have a right to refuse medical treatment. So for her to say this is pretty stunning, but I can tell you that it's the norm. We heard this kind of thing in the Winland case back in 1997. It's like she's echoing what we heard through the testimony in that case. Myself and a gentleman, Wesley Smith, whose name you may know, he works with the Patients' Rights Council. He wrote a book, Forced Death, which I highly recommend. It's quoted in our materials. He also wrote another book, Culture of Death. We sat in the audience during that trial every day and heard the testimony of the patient's right advocate, the medical experts, who sounded just like this public guardian for Rachel. And I sat in on it with the intent of doing the continuing legal education, Wesley to write his book. And what was really stunning to me was when the ombudsman came out after testifying, Robert Winland was cognitively disabled and he was fed through a feeding tube. His underlying medical condition was disability. He would never have died if his feeding tube was not removed. Luckily, the case went to the state Supreme Court. The feeding tube was not allowed to be removed. But the patient's rights person, the ombudsman, did not know that Robert interacted with a message board, that Robert could comb his hair and do some real simple things like wash his face. He could bowl from his wheelchair. And the ombudsman did not know that. And Wesley and I stopped this lady out in the hall just to see what kind of training that she had. And she kind of looked at the ceiling and said, well, the hospital sends us to Right to Die courses. So this is back in 97. But the point being that what the patient guardian said in Rachel's case was the same thing that we heard in the Winland case years ago. So today we want to prepare attorneys for the legal issues that will be raised, and a lot of it is policy oriented, and that's a lot of what we'll discuss today. the concerted effort to legalize intentionally allowing people to die. There are some materials in your handout. Appendix A is some reading on the topic of forced death. It's kind of like a little white paper. It's just a few pages, but it's interesting to read. We'll give you some background. I highly recommend Wesley Smith's book, Forced Death, and anything that he's written for that matter. He really knows these issues. This, ladies and gentlemen, is a battle of belief systems. Traditional Western ethics, all life is inherently valuable. All human life is inherently valuable. And what we're seeing is a battle in the culture that is saying human life is not necessarily valuable. It depends on your ability. It depends on your age. So, you know, if you've had a good life, better to just let you go. I'll give you an example of this. A friend of mine in Sacramento, her stepmother was hospitalized for a heart-related condition, and she had a feeding tube inserted through her stomach, and she was improving and doing better. She was in her middle 70s, and my friend Cindy was, communicating with the hospital staff, and the woman was improving, was getting ready to be released, and they said to her, and I quote, you could remove the feeding tube. She's had a good life. We can make her comfortable, and she won't have to go through this again. And thankfully, after hearing me all the time talk about what I do, she said, I don't think so. The lady is still alive today. And this was about 10 years ago. So there's that cultural battle that's going on. Okay. And this is really obvious to me and probably to you, not so obvious to some people apparently, but if human life is not inherently valuable, then what's to stop us from ending it? I mean, let's think about this in another context. We have a huge homeless problem. If their lives aren't valuable, then let's just solve the homeless problem. Let's just end their lives. Their quality of life isn't good. I mean, that may sound ridiculous to you, but I don't know if it's so ridiculous, knowing what I know from what we've been doing at Life Legal. So, killing disabled people has become legal by withholding foods and fluids. I mentioned early on that foods and fluids are considered medical treatment, and that's just the way that it is. I want to direct you to a United States Supreme Court case, Vacco v. Quill. It's not in your materials, the text, but it's cited. And in case you can't find it, because I'm not really sure what page it's at, the citation is 521 U.S. 793. This is a 1997 case, and the companion case was Washington v. Glucksberg. And in both cases, it was held that there is no constitutional right to physician-assisted suicide. It's a little bit different from the issue of removing foods and fluids, but I want to make the case that they're one and the same. So I want to read to you from Vacco v. Quill. I think the language is instructive. Now, in Vacco, this is the question that was presented: whether New York's prohibition on assisting suicide violates the Equal Protection Clause of the 14th Amendment. We hold that it does not. And so the court, I'm just going to sort of read through some of the key language to take you to the conclusion that I want to make based on the language in this case. It says, it's hardly unreasonable or irrational for the state to recognize a difference between allowing nature to take its course, even in the most severe situations, and intentionally using an artificial death-producing device. That key word, the key word there is artificial, because what do they do with the issue of foods and fluids? They say that it's artificial nutrition and hydration and call it medical treatment. So let's go on. The Equal Protection Clause commands that no state shall deny to any person within its jurisdiction the equal protection of the laws. The provision creates no substantive rights. States must treat like cases alike, but may treat unlike cases accordingly. And then they go on to say, everyone, regardless of physical condition, is entitled, if competent, to refuse unwanted, life-sustaining medical treatment. No one is permitted to assist suicide. So they're making the distinction between somebody wanting treatment or not wanting treatment and being able to say themselves, I don't want foods and fluids, stop, versus physician-assisted suicide, where somebody is, by law, like in Washington and Oregon, allowed to give you a lethal injection to end your life. And my question to you, ladies and gentlemen, is what is the difference? If a medical person can remove your foods and fluids, what difference does it make if it's medication or if it's food and water? They're still taking an active step to end your life, whether you want it or not. In some cases, people might ask to have their foods and fluids stopped. And that's certainly their right to do so under the law. You have a right to refuse medical treatment. But what if foods and fluids were simply foods and fluids and not medical treatment? So I'm kind of talking in circles here, but that's kind of the reasoning with classifying foods and fluids as medical treatment. It's not medical treatment. It's food and it's water. And since when is it okay to dehydrate and starve people to death? Since foods and fluids became medical treatment. I'm going backwards. Turn it right side up. Okay, here we go. See now, the case could be made that I'm cognitively disabled because I cannot work this remote. So let's end my life. I say that facetiously, but it's not funny. So in the name of privacy, autonomy, compassion, we're killing people by dehydrating them to death. And here is the cover of Wesley's book, which obviously I mentioned prematurely, but I highly recommend this. It's very educational. Tab 3 in your binder is the tab where there's more reading on the issues raised in forced death. So, I will keep clicking here. This is a point I want to make. We do not use the terminology end of life at Life Legal. Maybe we do sometimes, but we try not to. And the reason that we don't use the terminology end of life is it may not be the end of the person's life. It may just be that the person is going through a difficult time, they need medical care and counseling. We call it what we've sort of gleaned from VACO and the Glucksberg case. It's active killing. It's taking active steps to end somebody's life, or you're forcing somebody to die. And you're doing it, you being the medical personnel, through, I think, undue influence and coercion. And I'll give you an example. I was contacted by a gentleman's grandson who had had his feeding tube removed for 8 days. And the grandson was basically told by the hospital, do not give him water. And he would go into the restroom off his grandfather's room, and he would get a paper towel wet and he would wring it out in his mouth when nobody was watching, trying to hydrate him. So this gentleman called me, and he told me that when his grandfather was admitted to the hospital, I believe it was heart-related, he was hungry and he was actually asking for pizza. Now, this is kind of different because the man was not on a feeding tube. He was hungry, he was cognitive, he was asking for pizza. The medical staff at this hospital, who I encountered many times when I lived in Sacramento, I called their facility the death camp. They sort of picked on his wife. She was elderly, as was the grandfather. And they convinced her that it was in her best interest and his best interest to let him die. They did not feed that man. They did not give him, they put him on a tube. I misstated earlier, it was not on a feeding tube. They put him on a tube to give him so-called comfort care. And he had been in a coma for 8 days by the time that his grandson contacted me. And what happens is, in California, these are cases that go through the probate court. And you're dealing with judges who are typically handling property issues. And so you go to the probate court for these sorts of issues, and you file your pleadings. And I'll mention that in your handout, the sample pleadings are Appendix C through F. And these are the types of pleadings that you file. But from the onset, you're educating the court about what's going on. The court is used to dealing with property issues. The court doesn't understand all the policy that we're talking about, and that's part of what you do as a lawyer. You're educating the court, and you need to keep that in your mind constantly, because the court's not going to get it anywhere else. And so we went to the court. I was representing the grandson. The hospital was not yet represented. The procedure is to file an ex parte application for a hearing, which is what we did. We gave the hospital notice virtually as we were walking into the courtroom by fax. And the judge appointed an attorney to represent the patient. The attorney went to visit the patient. By the time he got there, the gentleman had passed away. So this was a case that I would call coercion, undue influence on this elderly woman who was not prepared to deal with what she had to deal with when her husband was hospitalized. And that's why I said to you earlier, you need to prepare your clients. You need to let them know if they have a good directive with pro-life language in it, it makes it much easier to say, this is what my loved one would want, and this is what they're going to get. And you could still end up in court conceivably, but it doesn't become a he said, she said. You have something in writing, clear and convincing evidence of what the patient would want. There was no directive in the case of this gentleman, and because of that, because of a lot of circumstances, he was just, they let him die with the permission of his wife, who was coerced. So, act of killing, forced death. That would not have been the end of that gentleman's life if he had received proper care. So that is the terminology that we'll use throughout the course. And today we're not talking about cases with ventilators or respirators. We're talking about cases that you'll encounter foods and fluids. That's what we're referring to today. We're not making the case that somebody that's in a coma and only living because they have a ventilator or a respirator should be kept alive. That's not what this is about. This is about taking away people's foods and fluids, their nutrition and hydration. Again, we're not talking about truly artificially prolonging somebody's life. So now we're going to talk about strategies and tactics. You have your hypothetical situation here where you have a loved one come in. This is much like either the Winland or the Shivo case. You have a spouse who wants to end their loved one's, their spouse's life by not giving them foods and fluids. And the spouse wants to end the life, the sibling does not. Maybe there's insurance involved. Maybe there's a significant other that's in the picture, and that's the reason for wanting to do that. So where do you start? This is where I want to talk about Robert Winland. If you look at your handout on about page 6, nope, sorry, it's before that. It's pages 3 and 4. There's a little bit about Robert Winland's case. So, the case kind of followed me wherever I went, Robert Winland, because I was working for a group called the Rutherford Institute when I first heard about Robert's case. And this is what happened. Robert was in a single-car automobile accident. He was in a coma for 16 months. And his wife was insistent that he got every conceivable kind of medical care that he could get for his condition. He was, his brain was injured in this accident. It was alcohol-related. He came out of the coma, and she, after a few months, changed her mind. She said, you know what? He's not coming home 100%. He wouldn't want to live like this, so please remove his foods and fluids. There were bioethics committee meetings at Lodi Memorial Hospital where the decision was made that that would be the ethical and correct thing to do. And there was a hospital employee with a conscience that called his mother and sister and said, you better get down here because they're going to remove his feeding tube. And the case ensued. So the sister and mother, Rebecca Vinson and Florence Winland, hired an attorney named Janie Hickok Cease who litigated the case. And they were calling at the time the Rutherford Institute seeking financial help because they didn't have the means to pay for an attorney. And for whatever reason, circumstances I don't remember, Rutherford was able to give them a little bit of funding, but nothing significant. So then I had left Rutherford and went to work for the legislature, and this case was ongoing, and they were in court battle after court battle. And if you look at page 8, we've listed the various procedural happenings in this case. There had to be a conservator appointed for Robert. There was no directive. The wife was appointed the conservator over the mother and sister's objections. We wanted independent counsel appointed for Robert. That went all the way to the Supreme Court. The court did not want to appoint independent counsel for Robert. And there were petitions regarding his no code status and all sorts of things. So by the time I went to work for Life Legal in 1997, the mother and sister were still looking for funding. And this was the first forced death case that Life Legal was involved in, and we made the decision that we would fund the defense of Robert's life. I mean, that's our mission, to give innocent and helpless human beings a defense against the threat of death. So we were able to help with legal research and funding. This is where Wesley and I were sitting in the courtroom watching what was going on, and that was how Life Legal came to be involved with these cases. Years later, we were involved with Terry Schiavo's case. Probably everybody here has heard about Terry Schiavo's case. Same scenario, different spouse. So, I mean, these probably are obvious to attorneys that do litigation, but you really need to know the facts. For example, in Terry Schiavo's case, it really didn't come to light until well into the case that there was a girlfriend and a child by the girlfriend. I mean, what was really the motivation behind him being her husband wanting to remove his feeding tube? So you need to know the facts, the underlying circumstances. All these things are part of educating the court. I want you to turn to Appendix B in your handout, because I want to show you what kind of education the court is going to get if you aren't there to intervene. Appendix B is actual transcript from Robert Winland's trial. And up in the corner is a quote from one of Wesley's books, Culture of Death. And this was key to the court, not this quote, but what we're going to look at in the transcript. This was key to the court holding that without clear and convincing evidence, Robert Winland's feeding tube must stay in. So in this quote, Wesley is quoting a Dr. William Burke, who's talking about what happens when somebody dies through dehydration and starvation. He says, a conscious person would feel it, dehydration, just as you or I would. They would go into seizures, their skin cracks. here's where this emotional stuff comes in again. Their tongue cracks, their lips crack. They have nosebleeds, dryness of mucous membranes, heaving, vomiting, and the list goes on and on. Hunger, and this could go on for up to 14 days. In the case that we talked about earlier, Rachel, her feeding tube had actually been removed for 21 days when the court ordered it reinserted. Can you imagine what that woman went through? So the testimony here is Janie Cease cross-examining Dr. Ronald Cranford, who was the medical expert in the Winland case, advocating for the removal of Robert's feeding tube. He ended up being the same expert in Terry Schiavo's case, advocating for her death. He has since been deceased not too long ago. So while you won't come up against Cranford in court, you will come up against people with the same way of thinking. So if you look at page 1 of this transcript, Ms. C says, you testified that in order to make sure that Robert, if his care is terminated, and his answer is, he interrupts and says, if his treatment is terminated, not his care, I'd like to use a different term here. So do you see the word games? We talked about foods and fluids being medical treatment. This expert wouldn't even call it care. He wanted it called treatment. So then it goes on at the top of page 2. Didn't you also say that the amount of morphine that would be necessary to give Robert would be an arbitrary dose? No, it would be arbitrary in the sense that since he has minimal cognitive functioning, it would be hard to know whether he's suffering or not. It's not an arbitrary dose in the amount I would give in the situation where I knew how much someone was suffering. You would titrate a dose up to keep them comfortable. So I don't know about you, maybe I'm not very well educated. I had no idea what titrate meant. So at the time I looked it up, and it's actually taking different medications and trying to come up with a certain effect by combining medications. So this is point number 2. If you end up having one of these cases, do not let this language intimidate you. Everybody has Google. You look it up and you tell the person that you're examining or that you're deposing, speak plain English. What are you doing with titrate, Dr. Cranford? You're mixing morphine and Valium and something else to get the result you want. What's the result you want? Well, you want the patient to be comfortable. Well, hello, you're putting them in a coma so that you can justify ending their life. So I don't know what you had in law school, but I had to read plain English for lawyers. We need to have plain English for experts in cases like this. Don't let them intimidate you. Make them speak plain English and explain exactly what they're talking about. So then as this goes on, down further, page 4, Ms. C starts to ask the questions that Dr. Burke, the quote earlier. Do patients have seizures? Do you give them medication to prevent it? Does their skin crack? And this is where Dr. Cranford tries to throw her off, for lack of a better term. And he says, you're reading the list. She's like, what list? You're reading the list, the right to life list. So immediately, what do you do in debate when you can't win the argument? You deflect the issue. What would the trier of fact, what would he think because of what goes on in our culture in the media with right to life? I've seen this a dozen times in cases that I've been involved with. You demonize the person that's actually got the intelligent scientific argument. Right to life, to get the judge off track. So Janie gets him back on track and goes through these list of symptoms, the list of symptoms that were just mentioned with Dr. Burke earlier. And that, ladies and gentlemen, is what saved Robert Winland's life. When the trial was over and the judge held that his feeding tube had to stay in, we asked the clerk after, what was it? Can you tell us what was it that made the judge decide the decision that he made? And they said it was the description of what happens to a person when they're dehydrated and starved to death. So back to my point, you're educating the court. You need to be aware of that and do that at all costs, because you literally could be saving somebody's life with bringing out what really goes on. It says here, know the client, know who you're representing and who's opposing, know your legal claims. I would add to that you really need to know the experts. For example, another expert that was brought in during the Winland trial was a gentleman named Larry Nelson, and I don't remember if he was a bioethicist or a medical person, but they brought him in because he was Catholic, and they could say, this is what people of the Catholic faith want. And so then, we're in the position of saying, not necessarily. So you need to really know your experts, and you need to make it really clear, if you're going to engage an expert in a case like this, that you expect them to keep everything confidential, because what happened in the Winland case is we had an expert, they had a phone conversation with Dr. Cranford, and all of a sudden we didn't have an expert anymore. And so then we had to go scrambling for an expert, which we were able to find, but know your experts and make things perfectly clear to them off the record that this is confidential, and please honor that. So the very end there, see resources in the appendix. That was what I referred to earlier, appendix C through F. You have your petition, which is your complaint, your memorandum of points and authorities, sample declarations, and a proposed order, which is where we'll talk about California law a little bit here. Back in 1999, there was an effort in our illustrious state legislature to streamline the probate code. The author of the bill was a pro-abortion Democrat, and the co-author was a pro-life assemblyman. And this was while Winland was in the Court of Appeal by this time. And I went into the pro-life assemblyman because he's somebody that I had known a little bit when I was working for the legislature, and I said, you can't co-author this bill. They're telling you that they're streamlining the probate code. Well, what they actually ended up doing is, if you don't have a directive, how many of you know that in California there is no descending order of the person who would make your decisions? It's gone. They streamlined the probate code. They took that out. So typically you think, if I'm disabled and I can't make my decisions, who will make them for me? My spouse. Not necessarily. They took that out of the probate code. If you don't have a spouse, your child. It's not there anymore. So you should know that that's no longer in the probate code. The other thing with these petitions, for example, in Robert Winland's case, there was thought after he passed away of bringing a wrongful death action, and there were certain people who had standing to do that. With this issue of who could bring a petition to try to intervene if somebody's not getting proper medical care, it can be virtually anybody. If you look at probate code 3203, actually it starts with 3200, but I'll read to you from 3203. It's who can file a petition. A petition may be filed by any of the following: the patient's spouse, a relative or friend of the patient, or other interested person. So virtually anybody can bring a petition to intervene. So if you're not involved in a case like this as an attorney, but you know of somebody that's undergoing something like this, you could bring a petition if you wanted to for a friend of yours, which is a good thing, I think. So let's move on. Again, know the facts. What's that they used to say in law school? Facts are your friends. How do you get these facts? Again, I think I'm stating the obvious to most attorneys, but you have to do some interviewing with the family. I'll tell you an issue that came up in Winland again. Rose Winland made the case that Rebecca Vinson and Florence, his mother, shouldn't be involved in any decision-making because they were estranged. They don't visit, they haven't been around in years, and that wasn't true. What was truly happening was there was a sort of a rift in the family prior to Robert being incapacitated, and they would see Robert, but they would see him when Rose was not there. An unfortunate family circumstance, but you really need to dig sometimes to get to the heart of the matter to be able to defend your client. And obviously, family disputes are messy, and the petition that you have in your sample pleadings isn't a family dispute-related petition. The petition you have in your pleadings is where the family wants treatment and the hospital is saying no. So this could come up in different scenarios. You could have a hospital that says we won't treat, like in the case of Rachel that I mentioned earlier. You could have a family dispute, like in Winland or Shivo, or you could have a family dispute where the hospital's kind of siding with whoever it is that agrees with their position. When you've taken the descending order out of the probate code, it's very easy for the hospital to go to the person that they think will make the decision that they want made. So that's the danger in having removed that from the probate code. And a really good reason why you should be advising your clients to have directives, because then it's crystal clear who they want making decisions for them. And along those lines, you need to advise your clients that if they're picking surrogates, they need to know what their surrogates are thinking. As a gentleman in the audience here today, Kevin Bedolla, who is an attorney that's been helping Life Legal with these cases, and we're working on trying to get, and mostly Kevin, trying to get a surrogate pool for people who have children who don't necessarily believe like they believe. I have relatives who I wouldn't want making my healthcare decisions. My son, yes. Some other relatives, no, because they don't think like I think. They might see the inherent value in a dog's life or a cat's life or a bird's life, but they don't see the inherent value in a human life. So you need to really advise your clients in that regard. And that's one of the things that I think is good about Legal Lifeguard and the reason why we want to become involved with them. They have an actual will that gives you the opportunity to sit down with your family and have these discussions. And it's a way not only to get to the heart of the matter with respect to your surrogate, it's a way to sort of pass your values on. Maybe they won't grab hold of your values, but it'll be in their mind and they'll know what you want. And it's kind of like good old Ronald Reagan. Not everybody believed the way that Reagan believed, but they respected him because he said what he meant and he meant what he said. And when you do that with your family, I would think the majority of people would respect your wishes. Maybe not, but that's really important, that you advise your client to know who their surrogate is and to be sure that they know it's not necessarily, they're not necessarily going to make the decision you might want them to make, and you better figure that out. So I'm going to stop at this point. We have about 10 minutes until our first break, and I want to see if anybody has any questions. When I went through this, I was looking at slide numbers, and I'm not looking at them today, so I'm kind of getting off track a little bit. But yes?
Sorry, rookie question here, but you say like client interviews and family and hospital interviews. So, for example, when you go to the hospital, like obviously, like the family members who want to save the person's life are probably going to interview easily.
Right.
But what about like the hospital staff who are, let's say, at least neutral to antagonistic? What mechanisms are you using are you doing depositions, or are you doing something else to get their interviews?
Well, it could be, the question was, for the record, is how do you get to interview family members other than the person that you're representing? It's difficult. I'll give you an example. First of all, I want to mention that there is before I forget, there is a sample demand letter in your handout as well, so that you can avoid litigation if you want to by sending a demand letter to the caregiver. So that's in your handout. I'll give you an example from a case I had. Most hospitals have they have either hospitalists, which is a physician that goes around and determines who gets care and who shouldn't get care, and they have bioethics committees who make decisions. In the case of Robert Winland, they had, what's the terminology here? They included in the bioethics committee hearings the immediate family, which was the wife and kids. They did not include what they characterized as the family of origin, which was the mother and the sister. I've seen where hospitals do include immediate and family of origin. Typically, you're going to be deposing people that are adamant about ending somebody's life. Like, for example, I think, and I could be wrong here, but this is my opinion from watching the Winland case and the Shivo case. Those spouses were wanting to remove feeding tubes, but they were used by the so-called right to die movement. And they fed their desire to want to do that. And so if somebody like that is advising them, if somebody like a Ronald Cranford is involved, you're not going to get any information unless you depose. I had a case in Sacramento at the death camp I mentioned earlier, where a mother called me and said, my son was in a single-car automobile accident, and his wife does not want him to have antibiotics while he's in the hospital recovering. I mean, what does that mean? That means they're going to get a staph infection or MRSA, and they're going to die. And this gentleman was in and out of consciousness, and I don't think he was on a feeding tube. I don't really remember. He must have been. He was in and out of consciousness. They kind of all run together. But this part I distinctly remember. She contacted me when they were to the point in the process where the bioethics committee was meeting and had met several times, and they were going to make a final decision as to whether or not they would not give him antibiotics. And so I said, okay, you go to the bioethics committee meeting. They were including her. I'm going to sit out in the hallway. I don't want to go in and you have an attorney involved, and right there, communication is cut off, hoping for a good result. So I sat out in the hallway and I said, if you need me, you come and get me. So sure enough, after about half an hour, she came out and got me. And then it becomes confrontational. The wife wouldn't talk to me. The wife wouldn't look at me. She wouldn't answer questions. And then they start this, privacy, HIPAA, all that sort of thing. So I said, fine, I just want to know where we stand. I've got lots of work to do. You're going to be served. So we filed an ex parte application. I called the legal department to let them know about this. And I was talking to the person in the legal department, and this is what they said to me. And this is true of every hospital that I know of. We don't care what the family wants. We don't care what the patient wants. We have our own protocols, and that's what we do. So if you don't fit in the little box, they call it feudal care. They don't call it feudal care. They used to call it feudal care until people figured out what it was. So anyway, I'm getting off on a tangent here. But as soon as the wife was served, she called. She wasn't represented by counsel. She called and said, we'll give him the antibiotics. Something interesting about that case is the gentleman was in and out of consciousness, and you'll find that they will treat an unconscious patient like they're a piece of furniture. This is another sort of pet peeve I have. When people talk about persistent vegetative state, we're not dealing with a vegetable. We're dealing with a human being. I call it a permanent unconscious state. And this gentleman was in and out of consciousness, and they would talk to him or about him with the wife. And do you know that that gentleman recovered and walked out of that hospital, and he lived, I think, about 5-6 more years. Didn't have a real healthy lifestyle, but he could remember the things that were said about him when he was unconscious, and they thought he couldn't hear. So I don't know what point I'm making here, other than These are not vegetables, these are humans. But typically you have to depose. I have not been involved in a case where the opposition will sit down and let you interview.
Like, preliminary, emergency deposition type of.
No, if you have a case where a feeding tube's already been removed, you have to look at your local rules, but typically you can go in ex parte. You really don't have to, you give the other side notice as a courtesy, but you typically, if they don't get it, too bad, and then you have a hearing within 48 hours. And then that's when the fun begins, because if you look at the procedural history with Winland, they were in and out of court forever. Then it went to the Court of Appeals, who reversed the decision, and then it went to the state Supreme Court, and they reversed again. And the holding in Winland was this. It was very specific. If you have a conservator, the conservator, which that's, there may or may not be a conservator involved in the case, cannot remove a feeding tube unless there's clear and convincing evidence that that's what the patient would want. And again, I don't know. I didn't talk to any of the clerks at the state Supreme Court, but I'm pretty sure that it was establishing a record, being able to see what it meant for this person to be dehydrated to death, and not really knowing if that's what he would want. And, we'll go into this a little bit after the break, being so cavalier about Robert and his condition, and, sometimes they have seizures, sometimes they don't. They're so far gone, they don't really feel it, that sort of attitude. Yes?
Dana, this petition covers the case in which there is...
See the mic.
This petition covers the case in which there is no prior medical decisions document or advanced health care directive.
Yes.
And if there is one, then you're recommending use this demand letter?
Yes.
Then if that, and you deliver that to the, legal department or somebody at the hospital. Mm-hmm. If that doesn't work, do you have any other sample petitions for the case in which there is a prior medical decisions document, or you just modify this petition?
We have never done a case where there's been a medical decision document. They're typically very effective. I think that if you had a case like that, and we'll go through this language in the second half of the CLE, there's some really good language in Washington v. Glucksberg that the companion case was VACO, and VACO even refers to it, where you make the case that this is the patient's rights, and there's it's the patient's decision, it's the patient's right to life, it's the patient's right to receive medical treatment, and then there are all these other public policy arguments that you can make about undermining the medical profession, and we'll go through those. But those are the sorts of arguments. If there was a directive involved and they weren't following it, I would make those sorts of arguments. And also, the demand letter makes it clear statutorily that, we're talking about this is the patient's right. This is the patient's decision. You shouldn't coerce. You shouldn't do what you think the patient might not want done. You don't know. You're not the family. So let the patient and the surrogate make the decision.
So the most difficult situation then would be if you had a prior medical decisions document that, say, named the wife, and she had made the decision that she wanted the food and hydration removed, and then the rest of the family who are not listed on the PMDD that they want the opposite, then it seems to me you got a real hard case then.
You do, and again, something else that we'll go through after in the second half is the three standards of proof that are in the various jurisdictions. There's some really stringent standards, and then there's a standard that the medical community likes to use, and that standard would make it really easy if they had a really good attorney that could argue really well. It would make it really easy not to follow the directive. So I guess in conclusion for this segment, what I want to say is you may be involved in a case where there's a directive and the patient's wishes are not followed. It wouldn't surprise me in the least, but I still think having a directive is the best way to protect yourself or your loved one. And I hate to be negative Nancy, but I think in our culture, and especially with the advent of Obamacare, we're going to see lots of people that are going to die. And that's why we've sort of resurrected this training, and we're trying to get this attorney network going, and we're trying to do it. For example, we'll do this here. It'll be available online, and we're working on Florida, and we're hoping that we'll make contacts in Arizona, and we're trying to do it so we can build this network so that, I mean, think about it. Nationwide, Kevin Bedolla and I, Kevin being the attorney that's been working with us on these things, we sat down one night and kind of tried to figure out how many people do we figure educated guess that are euthanized in the United States every year. And we think 100,000 is a low number. Now, that's not based on any statistical evidence. That's just knowing what we know and knowing hospital policy and kind of doing the math. So, and then if you read Wesley Smith's books, you'll see what we mean. And I would highly recommend that you read Wesley's books. So we're going to take a break now for 15 minutes, and we will resume at 1 o'clock and go through the second half of the materials.